Hey everyone, welcome back to another week of KNR 382. Our topic this week is on gender equity laws. So first and foremost, as we get into this unit, I want you to, first of all, leave your constitutional law mindset behind. In our unit on constitutional law, we kept asking this question about state action, right? Whether or not the defendant was a state actor and how that impacted the case. Moving forward here, looking at this week's content and even beyond, that question of state action is no longer going to be relevant, right? Because we're no longer talking about constitutional laws. Now we're talking about statutory laws, so laws passed by legislative bodies. So just keep that in mind in terms of who has to comply with the laws that we're going to discuss over the course of the next few weeks. We're no longer limiting that conversation to just state actors. So of course, remember the content you learned about constitutional law, but let's leave behind that constitutional law mindset in terms of thinking about state action. Okay, over the course of this week, we're going to examine a couple of different federal laws or statutory laws that are related to gender equity in sport and recreation. So for our unit today in particular, we're going to focus on Title IX, which is certainly a law that's had a major impact on sport and recreation in your lifetime and in mine. It's a topical item that we'll look at this semester. It can also bring up differences of opinion in students. So I just want you to keep in mind that whenever we're talking about issues like this where there can be some controversy or disagreement, just keep in mind that we always want to be respectful of each other and our opinions on the issues. Of course, as always, as we look at content in this class, we're looking at it from a legal perspective. So we want to look at how Title IX impacts what we do as KNR practitioners, and not necessarily about what our opinions are on that matter. Okay. So we're going to focus on Title IX. We're also going to identify a specific federal law that deals with pay inequity for gender, and that's the Equal Pay Act. So for our purposes this week, we're going to cover those two laws. As we get back together next week, we're going to explore a couple of other discrimination laws. So there will be a little bit of crossover in terms of your reading. So your reading assignment for this week, which is available on ReggieNet, make sure you're reading that. It's going to cover both Title IX Equal Pay Act and some of the other employment laws we're going to look at next week. So just keep that in mind. Okay. So before we actually get into Title IX and the Equal Pay Act, I think it's always important to begin this discussion by defining this concept of gender equity. We often hear this term gender equity. We also hear this term gender equality. And I just want to make sure that we understand the difference, especially when we're thinking about this from a legal perspective. So for instance, equality by definition is the state of equal access to resources and opportunities. So treating everyone the same without regard for differences, right? That's not very helpful in the context of the law. So what we really want to think about in this regard is gender equity. So equity actually accounts for those differences and basically gives everyone what they need to be successful when they recognize that certain people might require differences based on their place in the world. So in regards to gender, keep in mind that we don't all come into this world having the same privileges based on gender. So when we talk about laws related to gender equity, we're talking about laws that work specifically to fight against discrimination based on gender. And in this case, gender that has historically been unrepresented, right? Particularly in society, but also specifically in our case in sport and recreation. So women are the historically underrepresented sex in our society. And therefore, when we think about this concept of providing gender equity, these laws are put in place to try to account for that lack of privilege or those differences that come from being the underrepresented sex in our society. So again, just want you to think about this concept of gender equity over this concept of gender equality. We want to think about the differences in privilege and the differences society has created that make these laws necessary. Okay, so Title IX, I'm guessing you've all probably at least heard of Title IX as a law, but you might not know a lot of the history here. So keep in mind, Title IX is passed in 1972. So we have to think about the historical context of this, just like we did when we were thinking about some of the other laws this semester, the Constitution in particular, how it was framed at the time of the Revolutionary War. We also want to think about the historical context of Title IX. So if you think about back to the late 60s, which I don't think any of you were around for, neither was I, but this is a time where there is a civil rights movement happening. And there's also, in addition to that civil rights movement fighting for racial equity, there's also a women's right movement happening as well. So from a cultural standpoint, we see a shift happening here in society in terms of what a woman's role is. Unfortunately, prior to this time in the U.S., women are still facing extremely high levels of discrimination, especially in the workplace, especially in institutions of higher learning. So there's a real backlash from women in society saying, hey, this isn't okay anymore. We want change. You couple that with something else that's happening in the early 70s, and that's that Billie Jean King, who was the world's best female tennis player at the time, was actually put in a situation where she's playing Bobby Riggs, who was at this point a retired U.S. tennis player. But they played what's known now as the Battle of the Sexes. It was a televised tennis match between the two. It was hotly contested in terms of the outcome, right? Everyone was glued to their screens to see what would happen with this woman playing this man. Of course, the thought was the man would easily beat the woman, but in fact, she ended up beating him pretty handedly. So this Battle of the Sexes tennis match was a real jumping off point for Title IX. In addition to what's happening in society, right? This real shift or push for women to have the same rights as men. So keep in mind that historical context. And then fast forward to 1972 and the passage of Title IX. Keep in mind it's not its own separate law. It's part of this much bigger Civil Rights Act of 1964. So it's added to the Education Amendment section of this law. So it's actually just a small blurb in addition to much more text surrounding issues of civil rights. But you can see here, really the basic terminology of Title IX, and that's that no person in the U.S. shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So we'll talk about who has to comply with Title IX here in a minute based on that definition. But I do think it's important to note that, as you can see from reading the excerpt there is no mention of the term athletics or sport, right? So the initial purpose of Title IX is really to rid institutions of higher learning of discrimination. Again, like I said before, this time women were largely discriminated against in institutions of higher ed, to the point where women would apply to university and receive a letter back that said women need not apply. That thing was happening still readily at this time. So Title IX's primary purpose at the time is to rid or eliminate discrimination in education programs. Most of the lawmakers who are signing on at the time don't realize the ultimate impact this law will have on the athletics portion of higher education or other areas of education. So it's really not until later that we see Title IX have the impact on sports that we know it has today. So I just think it's important for you to keep that in mind, that the initial purpose or original purpose of Title IX really has nothing to do with athletics. It's just about providing an equitable ground for women to apply and attend universities in this country. All right, so what does Title IX apply to, or a better question, who has to comply with Title IX? So based on our reading of the law on the last slide, we can see that the scope of Title IX is actually pretty narrow, right? So we know that Title IX only applies to discrimination in cases of gender discrimination. Okay, so other types of discrimination is racial, discrimination based on age, That does not comply here with Title IX, only cases of gender discrimination. Second part here, only education programs have to comply with Title IX. So in the context of your reading for this week, you see that that means primarily colleges and high schools, and not just public colleges or high schools, right? We learned from the reading that really any educational program that receives federal funding, per our last prong here, tells us that those organizations have to comply with Title IX. And largely speaking, even if an organization is private, like a private high school or a private college, they're still receiving federal funding in some capacity, even if it's just that their students are receiving federal funding through grants or scholarships. So really all schools have to comply with Title IX based on this definition. Just keep in mind that we're talking specifically about gender discrimination in educational settings. Okay, so Title IX enforcement. So let's first look at the ways in which Title IX can be enforced. So one particular way, and one that we've seen a lot in our other legal concepts, is that a plaintiff can just file a lawsuit. So in this case, it would be a civil lawsuit, right, because we have no criminal action occurring. But plaintiff has the ability, if they feel like they've been discriminated against under Title IX, they can file a lawsuit against that school. Keep in mind that these are high school students, college students generally. The first thing on their mind is not always what legal issues can I, pursue against my school. So it's not as common as you would think for a plaintiff to file a direct lawsuit against their school, but it can be done. Another way Title IX can be enforced is through what we call institutional control. So every university has some kind of Title IX office or officer that is meant to deal with cases in-house. So we have a Title IX officer here at Illinois State University. So if there is a problem or a complaint in-house, that person would look into it and potentially investigate the issue. Finally, we do have a branch of the U.S. Department of Education called the Office of Civil Rights that can investigate issues surrounding Title IX. Now keep in mind that this office is pretty low in terms of staffing and resources, right? So they don't have the ability to go around the country and investigate every Title IX complaint. It's just not feasible. But if a case is severe enough and it's getting enough media attention, they likely will. I'm going to post this case or this article on ReggieNet for you to review. This was a recent Title IX investigation at the University of Iowa. It's pretty widespread in terms of issues surrounding Title IX that they were having there. This was a situation where the OCR did, in fact, go to Iowa and conduct an investigation. Excuse me. Okay, so those are the ways that Title IX can be enforced. I think it's really important to mention here that with Title IX, it really is a plaintiff-driven process, meaning that oftentimes schools may not be compliant with Title IX, but that doesn't mean anything's going to happen to them, unfortunately. It really does require someone speaking up in order for an investigation to occur. So when I say it's plaintiff-driven, I mean that we really do need the voices of those young women speaking up to say, hey, something's not right here. Because like we said, in terms of the federal government's role, they really just don't have the resources or the time to investigate every school. Okay, so what are the potential damages in the case of a Title IX complaint? Well, you can see here that probably the main source of damages in these cases is to simply rectify the situation, meaning that, oftentimes a student athlete might be suing a school for discrimination under Title IX, and they're not necessarily seeking monetary damages, although they can do that as well, but likely they're trying to get some kind of change to the system, right? Whether that's adding a sports team or providing more scholarship opportunities for the women's teams, providing better benefits in terms of facilities or equipment. Oftentimes that's what they're seeking. They want the situation that is currently not sustainable to be fixed. So that's often what they're seeking in a Title IX case. Like I said, though, it is possible to sue for monetary damages as well. One other line or potential line of damages for an educational program that's not deemed compliant with Title IX is this threat of loss of federal funds. So technically, under the law, the government could take away a school's access to federal funding each year if they're not compliant with Title IX. This just has not happened historically. So while that threat is there and might work to some extent to get schools to be compliant, there really are not evidence of cases where this has happened. So, in other words, the government has not acted on this threat, even though there have been several cases of Title IX noncompliance. Last potential line of damages here, certainly, the NCAA could act if they'd like. If a school is found to not be compliant, they could take away, access to championship competitions, or they could take back an actual championship. Those things, again, don't happen often in relation to Title IX enforcement. I would say probably the more common damages in these cases are to rectify the situation and potential monetary damages on top of that. Okay, so again, Title IX, as we know, is a broad law that applies to all discrimination related to gender across educational programs. So that means it covers everything, right, on a college campus and a high school campus, not just athletics. But for the purposes of our conversation, since we only have a week on this, we're going to focus by looking at the athletic requirements under Title IX, because again, that's probably the area that we're most likely to be impacted by as K&R practitioners, particularly for those of you that do want to go into the sport side of things. So keep in mind that as we look at these requirements here over the course of the next several slides, these are requirements or interpretations that were provided based on college athletics, but broadly speaking, they can also be applied to other sectors of the industry, including high school and other academic settings. So basically, in these cases of Title IX compliance, it's important to note that instead of the burden of proof being on the plaintiff, as it has been in several of the legal issues we've looked at, the burden of proof here is actually on the defendant, meaning that it's up to the defendant's school to show that they are compliant with Title IX, right? So they have to show proof of their compliance. Keep in mind, Title IX's passed in 1972, but immediately after, there is a ton of confusion in terms of how the law should be applied in athletics. Again, there's no specific way that's written out in the initial law. So there's a lot of confusion, and then ultimately in 1979, there's some more specific policy provided. Essentially, the government tells us there are basically 3 areas where schools have to show that they're being compliant with Title IX. That's in terms of their participation opportunities for student athletes. That's in terms of their financial support that they're providing these athletic programs. And last, the overall treatment and benefits they provide the athletic programs. So in a Title IX complaint, the school or the defendant has to be able to show compliance in all 3 of these areas. Our focus today is going to be primarily on this first part, the participation prong, but we'll also talk about the others as well. Okay, so again, after the passage of Title IX in 72, there is still a ton of confusion about how this will actually apply to college athletic departments. So in that clarification letter in 1979, they provide this 3-part test for schools to use to show that they are meeting that first prong, the participation prong of Title IX. Again, back to that participation prong, all that's saying is that men and women should be provided with equitable opportunities to participate in sport. And the clarification memo that is sent out says basically there are 3 different ways you can do this, right? There's not just one way. There are 3 different ways or options that schools have to pass this test. So you can see here they just have to meet one of these 3 requirements in order to pass the participation prong of the test. So we're going to look at all 3 of these here. We'll talk a little bit about the historical context of these tests and how maybe that's changed over the years since the passage of this bill. Okay, so this first potential tests that schools can use to show that they are compliant with the participation prong is what we know as substantial proportionality. So here, what we're looking at is amount of enrollment for the university or school. So what's the male enrollment at the university? What's the female enrollment at the university? And then we want to compare that data to the number of males and females participating in athletics at that school. Okay, so keep in mind, we're not just looking at overall number of male and female participants and saying they have to be the same. We're going to compare those numbers to the actual enrollment of the university. So basically, the Department of Ed has said as long as you can get within a window, right? As long as it's proportional, the number of athletic opportunities you're providing, as long as it's proportional to the amount of students enrolled in your university, then you can meet this substantial proportionality prong. Your book also calls this the safe harbor part of the test. You can see there that in terms of what percentage exactly we're looking at, unfortunately, the Department of Ed has never said a specific percentage. They've just said get as close as you can to zero. But of course, it's helpful to have some kind of guideline. You can see here from some prior court cases, we know that a 1.7% difference is acceptable. We know that a 10.5% difference has not been deemed acceptable. That's been too broad. And then other cases or settlements have showed that somewhere between a 3 to 5% gap is acceptable. So for the purposes of our class and this conversation we're having here, and then once we get in class and start looking at some practice cases, we're going to go with 5% as being a good percentage to follow when we apply this substantial proportionality prong. Speaking of, let's do that. Let's look at a couple example cases here and see if we think this particular school is compliant with the substantial proportionality prong of the test. All right, we know University X has an overall enrollment at the university that's 50-50, right down the middle. Again, in order to test for substantial proportionality, we have to compare those overall enrollment numbers with the athletic program enrollment numbers. So in this case, we know University X has 53% of their athletic program is made up of males, 47% is made up of females. So if we compare these two numbers, right, we have 50% male overall enrollment, and then we have 53% male in the athletic department. If we do a little math here, we see there's a 3% difference, right? Do the same for the females, right? 50% enrollment overall, then 47% enrollment in the athletic program. Again, same difference here, 3%. So if we go back to what we said on the last slide, which was that a 5% gap was acceptable, this would fall within that, right? So we would say that yes, University X's athletic program is in compliance with the first part of that substantial proportionality test. Okay, so again, this is just one potential test that the school could use to showcase that they are providing equitable participation opportunities for their student athletes. And if they're able to do that through this first part of the test, they don't even have to go on to the other parts. Before we look at those other parts, let's do one more example here. So this is University Y. University Y has enrollment overall at the university that's 44% male, 56% female, so a little bit higher on the female end. University Y athletic program participation here is 51% male, 49% female. So again, we want to do the same thing we did on the last slide and compare the male-to-male numbers with the female-to-female numbers. So if overall enrollment is 44% for males, but the athletic department's makeup is 51% males, what's our percentage difference? It's like a 7% difference, right? So if we look at the females, we should see the same thing, right? 56% female overall enrollment, 49% participation in the athletic program. Again, 7% difference. So what do you think? Is University Y's athletic program in compliance with the first part of the three-part test? Well, hopefully you come to the conclusion that it is not, right? Because again, if we're using our 5% substantial proportionality gap, this would go beyond that, right? 7% would be probably deemed to be too big of a gap in terms of proportionality. So they would not be able to pass this first part of the three-part test. Again, keep in mind that there are these two other parts of the test they could use to prove compliance. So even if they don't meet it in terms of numbers, there are a couple of other options for University Y. Let's move on to those. Okay, so the second part of the three-part test is what we call history and continuing practice. So basically, in order to pass this part of the three-part test, school just has to be able to show that they have a history of improving and increasing opportunities for female athletes. Right? You might remember a case from your reading this week involving Syracuse University. In this case, girls from the school's lacrosse and softball teams had filed a lawsuit claiming a Title IX breach. Right? Basically, in this case, the school was able to show that they were actually compliant because they had a history and continuing practice of expanding opportunities for females. And this was because they had added other female sports in prior years and had plans to add another. So even though they cut opportunities for some of their female athletes, they were still doing a pretty good job of providing opportunities over the years. So keep in mind that this part of the test, this part of the three-part test, gets a little bit harder to prove as more time goes on, right? So keep in mind, Title IX passes in 1972. So at the time, there's a pretty deep disparity in terms of male and female participation opportunities. So in those first, 10, 20 years following the passage of Title IX, schools could easily go to this part of the test and say, hey, we've done some work to add opportunities for females, right? Whatever it might be. Maybe we've added some scholarship options. Maybe we've added some more participation opportunities by adding teams. In those early years, it was okay to use this step or part to show, hey, we're increasing opportunities for women over time. The reason it gets harder as more time goes on is that over 40 years have passed now since the passage of Title IX. So basically, these schools have had, almost 50 years now to make appropriate changes in order to provide more equitable opportunities, right? So as a judge, you could argue, hey, you've had plenty of time here. What's taking you so long? And can you really use this history and continuing practice as a method to show that you're compliant, right? When you've had all this time and you've still not become equitable in terms of your offering. So it's still a part of the test that can be used to show compliance, and it still is used by a lot of programs. But keep in mind that I think at some point the courts will have to re-examine this, or the government will have to re-examine this in terms of whether or not it's appropriate anymore now that we're so far past the passage of Title IX. Okay, last part of the three-part test in terms of schools having a way to show that they are providing equitable participation opportunities is this accommodation of interests and abilities. So here, in order to prove this part of the test, the programs just have to show that they are meeting the current needs and desires of the females at their institutions, right? So basically, it just looks at the current makeup of student athletes at that university or school and asks, are we actually accommodating the interests of the students that we have? Okay. So you might be wondering, how would we measure this, or how would a school show that they're currently accommodating the interests and abilities of their existing students? Well, probably the best way to do this is to actually survey your existing students, right? Provide a survey, ask the questions, essentially, are we providing enough athletic opportunities for you as a student body? Collect that data. If you're going to use this as your argument for showing that you're meeting the requirements that are Title IX, you'd want that survey to show that, hey, yeah, the students are actually pretty happy with their options currently. So that's one way, and one common way to show evidence that you're accommodating the interests and abilities of your student athletes and your overall student population. There are a couple of other ways to examine this one. You could show that based on the current high school participation rates, current intramural participation rates, that you are providing appropriate participation opportunities. So that's another way to think about this third prong. So looking at high school participation rates, maybe participation rates for women's soccer has fallen, let's say. In that case, a school might be able to show that, hey, we are accommodating the interests and abilities of incoming freshmen based on the fact that this particular area has seen a fall in recent years. So that would just be one example of how you might use that information to show that you're accommodating the interests of current students. Okay, so those are the three options for schools when it comes to proving just that first prong of complying with Title IX, right? You'd have to show that they are providing equitable opportunities for both women and men to participate in sports. But again, they only have to meet one of those requirements in order to prove it. Maybe they're able to show it through the numbers, right? They can show that the opportunities for student athletes are proportional to the overall enrollment of the school. If they can't show it based on numbers, then maybe they can show they have a history and continuing practice of adding opportunities for women over time. Could be fairly easy to show that if you've added some teams over the past few years. Finally, if you can't prove either of those parts of the test, then maybe you show that you're meeting the current interests and needs of your existing students. So maybe you do a survey to show that, hey, even though our numbers might not quite be equitable, based on the current students that we have, we're meeting those interests. So those are the three options for a school to prove that they are meeting the participation prong of Title IX. Okay, so again, that's just the first part. We still have two other elements here that a school would have to show that they are also meeting. So financial support and treatment and benefits. So let's briefly look at those. Okay, so the financial support piece, as we think about it in the context of college athletics, is referring to scholarship dollars. Okay, so basically female and male student athletes have to be receiving scholarships that are proportional to their participation numbers as an athletic department. So this is pretty similar to what we looked at with the substantial proportionality prong, right? So let's look at University X here to show. University X athletic program, so again, we're not concerned with overall enrollment when we're looking at financial support. We're just looking at the athletic program makeup. So based on University X's athletic program, we know they're made up of 51% males and 49% females. We know that their scholarship dollars are distributed as follows. So 64% of the scholarship money is going to the male student athletes, 36% is going to the female athletes. If we use that same 5% bar in terms of proportionality here, what do you think? Is University X's athletic program in compliance with Part 2, the financial support? I think you could say that based on doing a little quick math here, it is not, right? So 51% of our athletic program is male, but they're getting 64% of the scholarship dollars, where 49% of our females are in the athletic program and just 36% of the scholarship dollars are going to them. So well beyond our 5% window here in terms of compliance. They would want to make some adjustments there in terms of how they're allocating their scholarship dollars in order to be compliant with Part 2. Okay, so the last prong here of complying with Title IX is that schools have to show that they are providing equitable treatment and benefits to their student athletes, regardless of gender. Okay, keep in mind, and this is a common misconception about Title IX, Title IX does not require athletic programs to have equal budgets, right? So we know that there are differences based on certain sports, right? The football team's new uniforms are probably going to cost a lot more than the volleyball team's new uniforms, right? Just based on the amount of equipment that comes along with that and based on the number of players, right? So we know right off the bat that the cost isn't going to be the same. But when we think about treatment and benefits, what Title IX is saying is that, yeah, they don't have to spend the same amount of money on the girls' volleyball uniforms, but if they're going to replace the men's football uniforms every 5 years, then they better do that for the women's volleyball team as well, right? So it's not necessarily about the amount of money that's being spent or what that overall budget looks like in terms of operations, but that we're providing equal or equitable treatment to the various genders, okay? So you can see based on Title IX and this particular prong, there are a number of areas or provisions where this equitable treatment or benefit applies. So As we already mentioned, it could relate to equipment or supplies. It also refers to scheduling of games and practice time, so making sure you're providing access to facilities for both your male and female athletes, and that they're getting equitable access in terms of times, meaning that you don't just let the girls' soccer team access the fields on Saturdays at 7 p.m., right? There has to be a fair allowance in terms of the planning and scheduling of access to those facilities. Travel and daily allowances. So if football players get $10 for lunch when they're traveling, the soccer team gets the same, right? So these sorts of things, you get the idea. There's some other benefits here in terms of treatment, so coaching, in terms of the access that student athletes get to coaching. If the baseball team gets one head coach and two assistant coaches, then the softball team should probably have similar makeup. You can see here some other benefits. So some dealing with facilities, some dealing with services. If you're going to provide an athletic trainer to the boys lacrosse team, you probably should also provide the athletic trainer to the girls lacrosse team. So you get the idea here in terms of benefits and treatment. A lot of this doesn't come down to providing the same financial budget in terms of operations, but just in general providing the same treatment to the female athletes that you do the male athletes. I'm going to post another article on ReggieNet here that's a great example case for athletes and coaches that filed a Title IX discrimination case, particularly around this area of not having fair treatment and benefits. And it's unfortunate that a legal case even has to come from this, because this should be the easy part, right? The hard part is probably providing equitable participation opportunities, but this should really be the easy part. Once you have the athletes, you should be able to provide them with equitable treatment once they're in your doors. Okay, so make sure you check that article out. I'll post it to ReggieNet. Okay, so real quick wrap up here. We've gone through all three sections of compliance here for Title IX. Again, remember that based on this policy interpretation from 79, schools that are having to show compliance, and again, that burden of proof is going to be on the defendant school, have to be able to show that they're meeting in terms of participation, financial support, and treatment and benefits. So all three areas they have to show that they're compliant in. And keep in mind that with that first prong, that participation prong, they can do so through any one of those three parts of that test. So keep that in mind. When we get back together for class on Monday, we're actually going to look at some actual Title IX data. So we'll look at some data for a couple of colleges and universities, and we'll get to apply this three-part test for compliance. I always like to end the conversation here on Title IX by just showing some of the numbers. So, in terms of what Title IX has done for female participation in both grade school, middle school, college, across the board, it's had a tremendous impact, right, in terms of providing opportunities for females to engage in athletic activity in this country. And I'm not going to read through all the numbers here, but you can see the massive difference it's made in terms of providing equity. Again, are we there yet completely? No. We still know that there are issues where schools are not compliant with Title IX in terms of participation or financial support. We know that, and even in some of the major Division I programs, that the amount of money being spent on those programs is not comparable. We know that there are some inequities in terms of coaching, and that, again, as I've stated before, a lot of programs still aren't quite compliant with Title IX, even over 40 years after the passage of this bill. So again, keep in mind we've seen a ton of progress, and progress continues to be made, but there's still some things we could do to encourage compliance. One thing that comes up that's somewhat controversial when you talk about Title IX is this impact it's had on men's sports. So as you read in your textbook or the excerpt I provided this week, you can see that An unfortunate side effect of Title IX, especially early on when it's enacted, is that some programs chose, rather than adding female participation opportunities, they chose to cut male participation opportunities. And while that is extremely unfortunate for those males that were part of those teams, I think it's important to note that overall, since the passage of Title IX, not only has the participation rate for female athletes gone up both at the high school and college level, but it also has for male athletes, right? So overall, participation numbers are up even for male athletes. So, while there have been a handful of programs cut by those schools in order to try to comply with Title IX, overall that impact I don't think is as large as it's somewhat cited to be, because overall we still have increased opportunities for both males and females. And again, that's something where those programs often have to make tough decisions. They're facing massive budget cuts and the realization that they have to make some changes in order to comply with Title IX. So, it's been an unfortunate side effect for, of course, a handful of those programs, but important to note that overall Title IX has had a positive impact. Okay, one last note here on Title IX. We're going to shift away a little bit from the athletics component, but something that I think is really important given what's happening at colleges and universities today is the sexual harassment piece of Title IX. So keep in mind that we know that the basis of Title IX is to rid gender discrimination from educational programs. And again, so far we've looked at it mostly from the perspective of athletics because that's what applies to us in our field. But I think it's important to know that in 2011, the Department of Education came out and basically said that sexual harassment and violence does interfere with the right to an education. So therefore, it is also a Title IX violation. So if any student is sexually harassed or sexually assaulted on a college campus, this is deemed to be a Title IX violation. So basically, what happened at the time in 2011 is the department stated that Title IX requires that schools have to investigate issues of assault or harassment within 60 days of an incident. So basically that the school isn't out of the picture if a student at their university is involved in some kind of criminal assault, right? They can't just pass it along to the local police department. The school itself also has to investigate and take action under Title IX. So keep in mind that some of this has changed in recent years. So 2011, this Department of Ed letter is released under the Obama administration. Once President Trump came into office, his Department of Education actually pulled back on those guidelines, and they have shifted some of those guidelines in terms of how schools have to comply with Title IX. They still have to be involved, and there's still an idea that they have to provide some kind of investigation, but the amount of time in which they do so is shifted in terms of not necessarily having to be such a quick turnaround, and also they're now requiring some kind of hearing to occur that would allow cross-examination of both parties involved. So a lot of controversy there as well that we won't get into. But note that this is a prominent issue on college campuses across the country, including here at ISU. And it's important that you know that this is an issue that falls under Title IX, that schools now have to investigate these issues. To bring it back to our field a little bit, I do want to show you another example, and I'll post the article here about this Jameis Winston case that some of you might be familiar with if you followed it in the news a couple years ago. Basically, Jameis Winston, when he was a football player at Florida State, had been accused of rape by a student also at Florida State at the time. The student went to the university to make a complaint, also went to the local authorities. The school basically did very little to investigate the case. In terms of their timeline, they waited a long time to actually give the information to the Title IX coordinator. You can see here in terms of the timeline, the alleged incident occurred in December 2012. Athletics was notified of that incident a month later. They wait almost a year, to November 2014, to actually alert the Title IX coordinator of the issue. So you can see, based on what we learned about Title IX and sexual assault and harassment, and what the Department of Ed had said prior to this point, that wasn't acceptable, right? They didn't actually examine the case in a quick and expedient manner. They didn't even actually bring him in. He refused to speak about the incident. And so it was kind of a mess in terms of how the school investigated this case. So the student, the accuser, actually filed a civil lawsuit against Florida State for their mishandling of that sexual assault claim, and she actually was awarded some monetary damages in that. So I'll post that article if you want to read a little bit more about that on ReggieNet. Okay, I'm going to pause right here and then do a second recording here on the Equal Pay Act of 1963, or the second part of our unit this week. I promise the second part will be much shorter. Okay, see you in a minute.